Time now for our Legal Insider segment. It's your chance to ask questions about law-related topics, and a lawyer from the Mike Murphy Law Group will do their best to provide answers and clarification. Today, we are pleased to welcome Aidan P. Murphy, managing partner with the Mike Murphy Law Group, and he's joining us in studio. Hi, Aidan. Thanks for coming in.
Thank you, Crystal.
Now, you're joining us today. You're in and out of the courtroom. We appreciate you being able to take time with us today. Tell us about the area of law that you specialize in.
So I'm split between two worlds right now. I do mostly injury and insurance, and then increasingly a lot of criminal defense as well.
Okay, why do you find this work rewarding?
Well, it depends on the client, but in general, I mean, both with injured people, which is most of our work at this point, and also increasingly in criminal defense, you really come at a time of need for the client. And even though sort of you can lose track of that as you're in and out of court, that's something that's exceptionally rewarding once you can sit back and appreciate what you've dealt with over the last week, and the clients usually are very appreciative.
I think we can all definitely understand that. We've asked our viewers to send in legal questions, and you get to answer the very first one. We've chosen this one. It's from Debbie in Dartmouth, and she asks, how much personal detail should be included when drawing up a will? Real estate investments, personal items, life insurance, should these all be included? Or should you assume your beneficiaries will be contacted by your lawyer or your insurance company? So let's break this down. It's Denise in Dartmouth. My apologies, Denise. Thanks so much for sending in this question. So it's about will. So in general, when how much detail has to go into making the will?
So there's a few different parts to the question. The first about how much detail to add. The general rule is you want to be more specific where you can be. So for example, if you execute a will and someone says, when I pass away, I give all my real estate to my spouse.
Okay.
Well, hopefully, if 15 years passes, you've been, married for 40 years and you pass away before your spouse, well, then all real estate goes to her. But occasionally that gap can be different. People can remarry. And then the questions that you can be left with are, well, what did he mean by spouse? Or what did he mean by real estate? So it's generally advisable that if you are going to be executing a will, that first of all, anytime there's a big life event, you should redraft it and have a lawyer do that for you. Or if there is, nothing significant that's happened, but 5 years or so passes, you'll want to redo that will. But in general, you want to be more specific rather than more general.
Okay. Now, I understand you don't have to have a lawyer to make a will, right?
No, you don't.
So, but why would you want to have a lawyer?
Well, it depends on the situation. There are lots of online will generators that there's nothing especially different about them that means that the will would or wouldn't be valid. The important part is whether or not that generator was built for your jurisdiction. And the Legal Information Society in Nova Scotia, which is run in part by our bar fees, has an online will generator that is excellent. And will work in most cases. I think the second part of the question was, naming the different assets. So real estate, life insurance policies.
Yes.
I think the important thing to remember when you're dealing with a will is that all a will is a legal document that says, I passed away. I named this person, who's my executor, to divide up the assets that I have. So it's not especially complicated in most cases, but the answer is mostly the same as the first question, which is, how specific should you be? Well, you should name those assets that you have some intention to give to a specific person or not. But you should also think that there are types of assets that might not actually form part of your estate. The two major categories are life insurance policies. We do a lot of insurance work. There are some policies that once you pass away, that money actually goes to your estate, but most name a specific person. And so in those cases, it doesn't form part of your estate. The other type is a joint asset. So joint bank accounts, jointly held property. If you own property with your spouse or your brother, a lot of the time that's jointly held. And so in those cases, if one person passes away, the other takes the whole of the property that you own together, and it doesn't form part of the estate. So the viewers in general should look to see, if you own property with someone else, what kind of asset are you owning, number one, and number two, is it something that's held jointly, or is it another type of ownership together?
Well, Aidan, it sounds complicated. It sounds like you would want to have a lawyer on your side to go through these important life decisions and update it regularly. But thank you so much for coming in and answering this question.
No problem.
What a pleasure. Aidan is with the Mike Murphy Law Group. Now, what I'd like to say right now is just a quick disclaimer. The information provided in this segment is of a general nature and is provided for information purposes only. It does not constitute professional legal advice. Please do contact a lawyer before making any legal decisions. And now it's your turn. If you have a question you'd like the folks at the Mike Murphy Law Group to consider, please send it to us by email at yourmorningatlantic.ca or text it to us at 10400. Standard messaging and data rates may apply. Do stay with us. Your Morning Atlantic will be right back after this.
This edition of Legal Insiders brought to you by the Mike Murphy Law Group.